Well, welcome back, everybody. Our next speaker is going to be a keynote by Maria Pallante. For artists, copyright is among the most important things in the world. It's also a topic that threatens to put many musicians to sleep, which is okay because most of them don't get enough sleep anyway. I'm reading a script. Although U.S. copyright law can be confusing, even to experts, it forms the foundation of practically every aspect of the recorded music industry. That means it's very important for musicians to have some understanding of how decisions around copyright affect them. Who better to fill us in than Maria Pallante, the Registrar of Copyrights and the Director of the United States Copyright Office. We are incredibly honored to have the Director here today to talk about copyright and the independent creator, and to hear about what the Copyright Office has on its current agenda. Please welcome Maria Pallante, Director of the U.S. Copyright Office.
Hello. I haven't started yet, and I already have a little bit of an inferiority complex because copyright is really exciting. However, I have to also note that a news report yesterday that one of my staff pointed out to me in the Arizona Daily Star described this conference in this way: band members from Olsa Motley and Cheap Trick, as well as less flashy representatives from the U.S. Copyright Office, will speak. It's okay. I'm fine with that, but I would like to spend at least a couple of minutes telling you about the very dynamic place that is the United States Copyright Office, because I really do believe that it's a wonderful example of government public service. So the mission of the Copyright Office is to promote creativity by sustaining an effective national copyright system. Indeed, we are the custodian and administrator of the Copyright Act. And copyright, as you all know, is partly commercial, but it's also a deeply cultural law. Congress centralized copyright functions in the Library of Congress in 1870. And then the official Copyright Office was established in 1897. Incidentally, that was the year that the law was first amended to protect against the unauthorized public performance of music. As the expert agency on copyright law, the Copyright Office is an important line of support to Congress, the executive branch, and the courts on copyright policy and related issues. The lawyers in both our General Counsel's office and our Office of Policy and International Affairs are among the finest in the country. They spend long hours analyzing complex issues that arise at the intersection of law, business, and technology. They also support bilateral and regional trade agreements of the United States in negotiations with core trading partners, and they assist the Department of Justice in litigation involving important copyright cases. Registration also feeds the premier collection of the Library of Congress, so each year the office acquires, through registration, hundreds of thousands of copyright deposits, including song lyrics, compositions, movie scores, sound recordings, and other musical works of authorship. Employees of the office are not only dedicated public servants, but they're also talented. Did you know, for example, that the examiners who register musical works in my office have specialized educations and experience in the performing arts? Many of them are musicians, and all of them have a deep and sincere respect for creative people and the way in which you make the world a better place. So in my job as director of the Copyright Office, I think a lot about the future of copyright law, just like all of you think about the future of music. How do we ensure that copyright law keeps pace with technology and provides a meaningful legal basis for authors, songwriters, musicians, performers, and other artists to make a living? These are big questions, but they're not unfamiliar. Legislators and courts have in many ways been thinking about them since 1790. Nor is copyright incompatible with a nation founded on principles of knowledge and free speech. On the contrary, the Supreme Court has called copyright the engine of free expression. I would like to share with you some of the current copyright developments my office is spending time on. But before I do that, perhaps because I spent the weekend thinking about music, or perhaps because it was cold and rainy and I was in a nostalgic mood, I found myself thinking also about the past, my own past, and what music and sound recordings have meant in my life. So here's my earliest memory. When I was small, my siblings and I had a small plastic record player in the house and a few age-appropriate 45 records, and I know I'm dating myself. You know, school days, and the teddy bear picnic. The quality was obviously limited, not to say the least, not to mention the selection, but that was my first memory of a sound recording. By age 6 or 7, I discovered the music at a friend's house down the block. She was the youngest in a large family of older children and had access to real music. In the 2nd grade, she turned me on to the Beach Boys and Elton John, and I had no idea what the lyrics meant, but I knew it was pretty cool. In 5th grade, I received a transistor radio from my grandparents that I still remember. It was shaped like a ball, had a chain for connecting to the basket on my bike, and transmitted, I don't know, maybe 4 stations, clearly. I remember sitting at the playground with my friends listening to the hottest band among 10-year-olds from that time, Captain and Tennille, and the Bee Gees. And at night, I kept it under my pillow and secretly listened to Casey Kasem's Top 40 Countdown until late into the night. In 7th grade, I received my best gift, my first 2 albums, Christmas presents from my brother, Fleetwood Mac Rumors and Chicago 10. Now, I should stop here and just say that I grew up in southern New Jersey, and I was heavily influenced as a teenager by what I still consider to be the greatest rock station ever, WMMR Philadelphia. I was dependent on my older sister, with whom I shared a room, for the actual stereo to play my music when she wasn't monopolizing it with Led Zeppelin and Pink Floyd. I'm not sure how many hours I spent absorbing album art and liner notes, but it was pretty significant. By the time I graduated from high school, I had acquired most of the album collection, which I still have today. Styx, Peter Frampton, Bob Seger, Billy Joel, Meat Loaf, Neil Young, Zappa, the Eagles, Crosby, Stills and Nash, Grateful Dead, Charlie Daniels Band, George Thorogood, Rolling Stones, Steve Miller Band, and yes, Cheap Trick. Driving, of course, is a core part of one's high school and later college years, and the cars I drove always included cassette players, usually retrofitted. My cassette tapes were in huge boxes on the floor. Tom Petty, Eric Clapton, James Taylor, Carly Simon, The Police, Neil Young, Peter Gabriel, Human League, Van Morrison. The memories of music are definitely intertwined with the periods of my life. Then while in law school here in DC, I met my future husband. He was 2 years ahead of me, played the keyboards, and introduced me to performances at Wolf Trap and Blues Alley. Al Jarreau, Chaka Khan, McCoy Tyner. When I was miserable in torts and civil procedure class, he suggested that I take copyright. He moved to New York City before I graduated, but he gave me a gift for the train rides that defined the next 2 years, a portable compact disc player and a couple of CDs from the artists that he thought might be compatible with legal reading, Dave Grusin and David Benoit. This was a defining period for me in terms of my profession. However, it was intertwined with music. And I can't really mention it without also mentioning the greatest rock concert that I've ever attended, which was the free Nelson Mandela concert at Wembley Stadium in 1988. Dire Straits, Eric Clapton, and the debut of Tracy Chapman. Obviously, compact discs have had staying power. When my children were little, my husband and I quickly reached our limit with Wheels on the Bus and other toddler tunes, and so instead we brought them CDs that sometimes raised the eyebrows of other parents. The Beatles and Santana were their favorites. Though I still remember my son's pre-K teacher telling me that he wanted to sing Sheryl Crow's Soak Up the Sun instead of I'm a Little Teapot at the graduation ceremony. I will mention here that despite my previous reference to the Teddy Bear Picnic, I have since discovered an awesome Jerry Garcia recording of that song. You should check it out. 5 years ago, I received my first iPod as a Mother's Day gift. I still have it because it's engraved and it's pink, and I actually think of it as a piece of visual art. But since I've since migrated all of my music to my laptop and my iPhone. I love iTunes, I don't mind saying, but like everyone else, I've also toyed around with Rhapsody and Spotify and other music streaming services, mostly today out of professional curiosity as a copyright lawyer. So you might be wondering, are there any lessons from my past that inform my role as Register of Copyrights? Well, lesson one, I may have spent a little too much time in my youth listening to rock in Philadelphia. Lesson 2, as for so many people, music and the platforms in which to enjoy it have often come to me as a gift. For me, that has also meant owning physical or downloaded copies of recordings most of the time, though that is changing as I, along with everyone else, learn to leverage the cloud. And third, it's the music, right? In the end, it's all about the music, the composition, the lyrics, the performance, the sound recording. The music is the point, and ensuring a culture where creativity can flourish is the point of copyright law. So at this point, I feel some obligation to conduct a bit of a pop quiz. Copyright is the single most valuable tool of creative people, other than the talent and drive, perhaps, that compel you to create in the first place. And copyright isn't really one right. It's a bundle of rights. So who out there can yell out the 6 exclusive rights under copyright?
Digital distribution, public performance, public display, right of reproduction, derivatives. Thank you.
Did you say distribution?
I did.
Display?
Yeah.
All right, very good. That's impressive, and those are rights that all of you should know. You should know all of the exclusive rights, and you should know how they interact, and you should know how they affect your contracts and how they affect the way in which music is made available. And keeping copyright law relevant is hard work for us. It involves a lot of technical analysis, a lot of tenacity, and committed policy leaders. So before I end here today, I'd like to mention the work that my staff and I are working on with members of Congress and with our colleagues in other agencies of the United States government. So on the domestic front, you may have heard about rogue websites. Both the Senate and the House have been considering this issue. Rogue websites are like just what they sound like they are. Egregious sites dedicated to systematic, large-scale infringement. They're often based offshore. They use advertising and American credit card companies to process their payments. Both prosecutors and copyright owners need more tools to deal with them. In March, I testified before Congress on this issue, suggesting that Congress craft a solution essentially by following the money, starving the rogue websites, and allowing legitimate business to flourish. A related issue is illegal streaming. Now, illegal streaming is really a parity issue. Prosecutors have long had the discretion, in the criminal context now, of bringing felony actions for the rights of reproduction and distribution. But as streaming becomes more popular, it's really the right of public performance that is implicated more and more, isn't it? And if that is implicated by illegal conduct, it follows that prosecutors who can only bring misdemeanor charges will not pursue that activity. It's time to elevate the public performance right. Another issue is small claims, sort of the other side of that, the other end of that spectrum of enforcement. Not all enforcement issues involve large-scale criminal behavior. Yet in civil claims, copyright owners cannot always afford to pursue disputes in federal court. Federal court's expensive. My office has recommended in the past and will continue to explore alternative options for small copyright owners and for disputes involving real but limited amounts of money. The public performance right in sound recordings. My office has been on record on this issue for decades. The United States needs a full public performance right in sound recordings. Termination issues. We are now in the first year into 2011, where songwriters, artists, and other authors, or their heirs, can terminate licenses made 35 years ago. To the extent these musical works are still viable, and there are many that are still viable from that era, this is an opportunity to recapture rights and renegotiate terms. My office has run several public proceedings on the issue of termination, on issues related to termination, including one about a perceived gap between some of the provisions and how they interact. The Future of Music Coalition filed comments on this point, and I would encourage you to look at those comments online. I don't have time to quote the entire thing, but they were the only group that made the important point that this second bite at an apple is even more important than it ever has been because there are so many new ways and new business models on the horizon for artists to exploit their rights and license their rights, including independently. Finally, internationally, you may have heard that last week, the body of the World Intellectual Property Organization, known as General Assemblies, approved a recommendation from the member countries, including the United States, to move to a diplomatic conference for the purpose of negotiating a treaty for the rights of performers in audiovisual works. My associate register is on the US delegation, currently in Geneva. Moving to the diplomatic conference signals a high likelihood of success on this treaty, which has been pending for many years. A treaty would strengthen the position of performers in the audiovisual industries by providing a clear legal basis for the international use of audiovisual works, and that's both in traditional and digital media, and also help protect against the unauthorized use of their performances in audiovisual media, such as television, film, video, and social media. The diplomatic conference is scheduled for June 2012. China, Mexico, and Morocco have all offered to host it. So I think I'd like to end there and offer, if I have time, to take a few questions from the audience. But thanks so much for your attention, and I know that you all think copyright is very exciting. Thank you.
Thanks for coming. Really appreciate you being here. I write for the Chicago Tribune. I just wanted to ask one question. There's a disconnect between the law right now, the way I see it, and the way people actually behave in the privacy of their own homes, which is the substantial portion of music that's dealt with digitally in this country is accessed illegally according to federal law. And I'm just wondering if you could address that. How you hope to look at this issue in the next few years. I mean, do we see a point where people are going to be prosecuted at some point for this activity? And how will you narrow that divide between how people are actually behaving and what the law is telling us in regards to copyright?
Thanks for the question. Those are really good questions. And we spend every day, all day, thinking about these questions. So you used the word prosecute, so I'll start with that. So prosecution is a criminal term, and it refers to a level of activity, infringing activity, that is egregious, willful, and large scale. Whether somebody in the privacy of their own home is engaged in that kind of activity is really like asking, are they really pirates? And so to the extent they are, then those kinds of criminal prosecutions would be appropriate. And that's one of the reasons that felonies, that streaming, for example, if they're streaming live sports programming, they're streaming music, if there's only a misdemeanor, ultimately the other end of that action, it's not really going to give prosecutors the tools or the incentive to go after them. But let's step outside of the home for a moment and just talk about the digital marketplace. There are always going to be two parallel tracks with the digital marketplace. One is enforcement, and copyright since 1790 has meant that Congress has had to manage the relationship between technology and copyright law. That's not new. What's new is the proliferation of digital media, which means that not only are business opportunities new, but new ways of infringing are difficult to keep up with. And that's a real challenge. But I think this Congress in particular is just doing a hell of a job trying to stay ahead of some of these issues and come up with innovative solutions. So the DMCA was an innovative solution a while back, and rogue websites, for example, would be another kind of innovative solution in that it brings in many moving parts. It brings in tools to get at offshore activity. It brings in good corporate behavior. It brings in notice, and it brings in possibly a private right of action for some copyright owners. Not for monetary relief, but for injunctive relief. So they're doing just, in my opinion, a phenomenal job of trying to find the sweet spot between a flourishing internet that is the future dissemination platform for artists and also stopping the illegal activity that they have to manage. And then the other side of that, of course, is new business models. So this is where copyright owners have to participate in making their works available in viable ways. It's a never-ending obligation. You absolutely have to do it, because if there are no viable, cost-effective ways to access your works legally, people will still access your works. So traditionally, Congress and the Copyright Office haven't spent as much time focused on kind of monitoring the marketplace as opposed to legislating. But I think actually there are many opportunities today for us to help facilitate things that have nothing to do with legislation, but which would really benefit copyright owners.
Thank you. Question for you would be, what role do you see the government playing in the transition to the new digital music industry? Traditionally, you had gatekeepers that let in to the system less than 0.5% of 0.5% of 0.5% of those people who generated musical copyrights. With digital technologies now, you're having hundreds of thousands of copyright creators having access to put their copyrights into the global infrastructure. The traditional PRO, mechanical royalty collection agency system, is broken. As a point of fact, my constituency earned between $100 to $150 million in songwriter revenue, and weren't able to collect it when it's black box and got distributed elsewhere. Lack of transparency with the current traditional PROs and regarding rates and fees. What role do you see the government playing in helping to change or shape that moving forward?
Another excellent set of questions. So I wouldn't say that the PROs in this country are broken or lack transparency relative to PROs in other countries. So I just want to kind of put that in perspective, that and they have been hobbled, right, by, I mean, in many ways, they were the most innovative creation of all back in 1914. And if you think about it on that spectrum, like how cool was that they devised a system for paying people for the performance of recorded music, or for musical works. I think they've been hobbled by legitimate concerns, antitrust concerns. It may be time to look at those again. And I would say that at a very high level, the irony perhaps is that other genres are looking to the collective licensing, blanket licensing models that the music world has had for such a long time as possible routes for the future. And if that's the case, whether it's for the mass digitization of books, or for education, or for libraries, then we really do have to figure out cost-effective point-of-sale licensing, including micropayments. So what can the government do? It may be, those may be exactly the kind of research topics and discussions that may not ultimately require legislation, but we probably have a pretty interesting role to play, and maybe for the first time.
Thank you. Hi, I was just wondering, sort of related to the previous two questions, do you think that Congress is really best equipped to deal with these disruptive technologies? Because my understanding is that in the past there's been sort of a 10 to 15-year lag where the technology was sort of, everyone was allowed to get used to it and judges were evolving case law. So do you think that legislation is really the best route to deal with these new issues? With these new infringement issues, is that what you're asking? Yeah, infringement issues and sort of how to fit this square peg into a round hole. Right. There is always a delay between obviously technology and then legislative solutions to maybe constrain it or provide a roadmap for how it could work legitimately. And that's obviously not a new issue. It's been the case since we went from silent films to talking films to DVDs, et cetera. And it will continue into the future, but by and large, I actually think that Congress in this country has done a really good job of managing the relationship. And the leadership that we have on the Hill today in both the Senate and the House is very interested in innovative solutions. So I think they're interested in part in legislative updates to the law to keep it working, but they're also interested in good corporate practices and
For example, providing a roadmap for legitimate businesses to flourish. So I'll take the example of cyber lockers, right? That's an issue that's come up in the context of rogue websites. How do you measure a cyber locker that's got substantially infringing music, movies, books in it? You can't, because it's not clear what they have in there, so you can't do it proportionately. You can't say it's mostly infringing material. All you might know is that your material is in there and available for download. So how do you get at that? Well, if you over-legislate that issue, then you run the risk of messing up the new business technology of cyber lockers and the cloud generally. So how do you do it? Well, one way to look at it is, how do you come up with a perfect definition? Another way to look at that is to say, how do you come up with the rules and corporate practices that legitimate businesses could look to know that as they build and invest in the marketplace, they know that they're doing something that will be okay. So I think Congress can't do it all. I think obviously we need good federal court decisions. We need the executive branch agencies to speak with one voice. We need also kind of the fourth branch of government, the administrative agencies charged with intellectual property, to be well-funded and well-staffed and to have some vision. So that, and that obviously the Copyright Office is one of them. I'm getting the time card here, so I'm just going to leave it to leave it to you to tell me when to stop.
Going off some of the previous questions and what you just stated, I know that there was a United States District Court decision in New York about the digital music lockers, and that under the safe harbor clause of the Copyright Act, that music royalties didn't have to be paid for these types of services. Do you see any new future legislation regarding these types of services, or regarding, I guess, as technology advances, what necessarily falls under the safe harbor clause and determines that these royalties don't have to be paid to artists and record labels?
Well, again, I'm very impressed by the level of questions from this forum today. Excellent question. I can't speak for Congress. I'm just the Copyright Office that does research and supports and works to help them. But I will say that obviously any decision where the person who created the work ends up not benefiting while everybody else has access and enjoyment is not a good solution, and one that would be very, very troubling to us if it were to become a pattern.
I wanted to say thank you very much to Maria Pallante.
Thank you.